consistent with what Senator Sessions, the issue Senator Sessions raised earlier. There is an op-ed in the Wall Street Journal today that I'd ask unanimous consent
objection
made part of the record. And I would just say I appreciate the chairman holding over the Kagan nomination for one more week, so perhaps we can follow up with some specific questions. She did a lawyerly job of parsing the questions and answering the precise question and not volunteering any other information other than what was precisely requested. So I think there are.
That'd be such a break in precedent, I'm sure.
It was it was impressive, but there are some clarifications, particularly with regard to the reach of the Commerce Clause and the federal government's power. And I would say that the chairman mentioned her statement, her testimony, that she would tend to defer to Congress in interpreting its own power under the Commerce Clause, which actually is a very disconcerting thought to me. Not that I don't believe that Congress ought to be able to legislate within the constitutional authority we've been given, but the idea that the Supreme Court of the United States, the guardian of the Constitution of the country, would somehow defer to Congress in interpreting the reach and breadth of its own authority is pretty astonishing. I thought the court's obligation was to enforce the Constitution, not to defer to Congress in interpreting its own constitutional authority. So I appreciate the opportunity to follow up with perhaps some more questions of Ms. Kagan and look forward to voting on her nomination next week.